Hi everyone. In this lesson we'll be talking about at-will employment. So at-will employment is the default setting for employment in the United States, and that includes North Carolina. What that means is that both parties, the employer and the employee, are free to terminate the relationship whenever they want and for most reasons that they want. We'll get more into those exceptions later. But in most cases, an employer can terminate an employee's employment whenever desired for any reason or without providing a reason at all. And in most cases, an employee can leave for any reason or without providing a reason at all. It's common for people to give some kind of notice. You often hear about a 2 weeks notice or something like that. But that is not a legal requirement. That's a common courtesy when you're trying to leave on good terms to get a good reference and stuff like that later. You usually don't want to burn bridges in the business community because you never know when that can come back to bite you later. But again, not a legal requirement, just a common courtesy. Things or people that are excluded from at-will employment. So we're going to start getting into these exceptions. So people with a collective bargaining agreement, these are union workers who have collectively bargained with their employer and formed this contract. They're excluded from at-will just because their employment will be guided by their contract. Similarly, if you have an individual contract with your employer, then you're excluded from at-will because, again, your employment relationship will be guided by the contract, which is usually going to give you a lot more protection than the general at-will rule. Many government workers, because, again, they have higher levels of protection than just simple at-will rules. In these cases, the relationship is governed by the contract rather than just the will of the parties. Every state except Montana in the United States is an at-will employment state. Montana is the only U.S. state not considered an at-will. It's considered more of a for-cause or just cause state where you have to have a really good reason once an employer has been on for a certain amount of time. But unless you live in Montana, you're going to be living under some version of at-will employment. Now, each state can set various rules regarding the kinds of exceptions that apply and the kind of protections that apply. So it's important to know where you are and what the rules are for your state. I'm going to be talking about North Carolina because that's where I'm teaching the class and that's where most of my students are here. Okay, so let's dive into some more exceptions here to at-will employment. Otherwise, when is it illegal to terminate someone's employment? Well, the first one is statutory exceptions, meaning that if the federal or state government has passed some statute, some law that would provide some protection, then that is, of course, a very important exception. And we spend a large part of this course talking about these exceptions in much more detail. But unlawful discrimination under Title VII, which is going to cover things like race, color, gender, national origin, religion, the ADA, which protects people with disabilities, the ADEA, which protects against age discrimination for people over 40, GINA, which is the Genetic Information Non-Discrimination Act, which protects against discrimination due to your genetic information, and USERRA, which protects against discrimination against members of the armed forces. And then if there are any other employment discrimination laws in your state, then those would be exceptions. Okay, so I can't just fire somebody because of what race they are, what religion they are, in most cases, if they're covered under this statute. There's also a public policy exception. So doing something that would otherwise cross or go against some other statute somewhere. So some examples of this can be informing of an illegal activity. I put an asterisk there because we're going to talk a little bit more about that in just a minute. That's not a blanket, always protected kind of thing. You have to be very careful about that one. Refusing to do an illegal activity if your boss tries to tell you to do something to be illegal. serving jury duty in North Carolina, you're protected from being terminated for that because we think it's a good thing that citizens should serve on juries, and it's not really good policy, good public policy to allow people to be fired for doing that. Performing some type of statutory right, some type of right that is given to you under a federal or state statute, things like voting or filing a workers' comp claim, and then finally testifying in court. A little bit of terminology here. Retaliatory discharge is the name we give when somebody is terminated in retaliation for something. Okay. And usually we're talking about something that would otherwise be covered under one of these exceptions. So we could say in this example, the employee was participating in some type of protected activity. They suffered some type of adverse employment action. That could be termination, that could be demotion, it could be moving you to another territory, whatever it might be, something that would be considered to be a bad thing at your workplace. And there was some kind of causal connection between the two events. In other words, the adverse action that I suffered was related to or because of my participation in this protected activity. In a case, Burlington Northern versus White, it expands the definition of adverse actions to anything a reasonable employee would view as being significant, not just firing, not just demotion, but there's all sorts of things that can happen at work that you would view as being some type of punishment or devaluing of your employment. I said we're going to talk a little bit about whistleblowing. Okay, this is informing about some type of illegal activity. Whistleblowing is the common name given to it. I've also noticed I had an extra space. Let's fix that. Okay, so in North Carolina, the basic advice that I will give you is that in North Carolina, don't just go around calling every news station when you think your employer is doing something wrong, because you might not be protected. I would recommend consulting an attorney before participating in whistleblowing activities, especially if you're not a state employee. State employees are given more protection for whistleblowing. If you're a private employee, really need to talk to somebody about this, because you might be surprised the things that you can get fired for, even when you think you're acting in a morally justifiable way. Constitutional protections. This applies almost exclusively to public employees, because the Constitution gives some protection against government action against citizens. And if I'm working for the government, then the government would be the one that is acting against me. So I have some protection under constitutional protections like freedom of speech, freedom of religion, stuff like that. In North Carolina, one thing that we saw was the North Carolina Magistrates Recusal Bill. This came down as a result of when the United States Supreme Court legalized gay marriage in the United States, pretty much nationwide with their decision in Obergefell. Some magistrates said that their religious beliefs conflicted with their ability to perform these types of marriage. In other words, if they were going to marry a gay couple or officiate that wedding, that would conflict with their religious beliefs. So this recusal bill allows magistrates to recuse themselves. The stipulation is there is that we have to be able to find somebody else who could actually perform that marriage. The Worker Adjustment and Retraining Notification Act, from now on, we'll just call it WARN, is this law that says a company, if they're going to have a plant closing or a mass layoff, they have to give 60 days advance notice to the workers and to the state and local governments of this plant closing or mass layoff. This doesn't apply to everybody, but we can look a little bit more closely at who it applies to. It applies to employers who have at least 100 full-time workers, or they have at least 100 employees who work a combined 4,000 hours or more per week. So we're talking about mostly larger employers here. The Act defines a plant closing as being when a single site is shut down. It could be, it could be that an entire company only has one site, which would make sense. It could be that a company has multiple sites across multiple counties or multiple states, and one single site is being shut down. This triggers the WARN Act if 50 or more full-time employees will be terminated within any 30-day period. A mass layoff is defined as losses of 500 or more full-time workers in a 30-day period, or between 50 and 500 if that amount of workers would constitute at least 1/3 of the workforce. So this will trigger some state action to try to figure out how to retrain, replace these workers and get them into different jobs. And there will be some statutory stuff that happens there. As an employer, you just have to be aware of your obligation to file this WARN notice if you're going to have a plant closing or a mass layoff. There are some exceptions to this. There are some exceptions where there's no notice required, and that could be that we had a temporary facility or a temporary project that was never designed to be ongoing. Now, as long as the employees understood that it was temporary when they were hired, then we don't have to give notice. Also, if there are layoffs due to strikes or lockouts, then no notice is required. There's an exception where I still have to give notice, but shorter notice is allowed. I'll have to justify this to the state when I give this notice, and they'll have to accept my justification. But it could be that just some unexpected business circumstance that was not reasonably foreseeable happened. There's not a clear-cut definition of what that means, but if I can convince the state to accept my reasoning, then I can give shorter notice. Or if we're dealing with a faltering company that just is on the brink of financial collapse and just doesn't have 60 days of operating time to give notice, or it could just be the result of some natural disaster. Again, those are usually not reasonably foreseeable. And then I give you a link there in the notes. You can download the notes document, keep them for your own records. And then you can follow up on all these links to learn much more about these topics that we're talking about. A little bit more terminology here. Constructive discharge is a name that we give to when I've terminated an employee. And let's say I know that I can't legally terminate somebody. Let's say I have a worker who I find out they're pregnant, and I think this is going to cause a huge headache for me, but I can't just fire her for being pregnant. So what I do is just make her life completely miserable, hoping that she'll eventually just leave on her own accord and of her own decision. That's called a constructive discharge. And if the employee can demonstrate that that's what's going on, then I'm still going to be held liable for my illegal activity here. So, try not to do that. It should go without saying here that it would be a bad thing to fire somebody just because they became pregnant. So let's get that out there. Another exception, if the termination results from a wrongful invasion of privacy. This applies mostly to public employees working for the government, but could apply as well for private employers. You have to be careful not to invade your employees' rights to privacy and then take action against that if my invasion of their privacy is wrongful. I gave you another link for some other North Carolina specific protections there. Mostly is all covered in the list I just gave you. Okay, let's move on. Now I'm just going to give you some employment discrimination concepts. We're just going to introduce a little bit of vocabulary here to try to get everybody enough of a foundation here. We're going to bring up all these topics several times as the course progresses. So just getting some of those definitions out there ahead of time. One of those is disparate treatment. Okay, when I'm talking about when people are being discriminated against in the workplace, there's a couple different forms that discrimination can take. One of those is called disparate treatment. Another one is called disparate impact, and there's a difference. Disparate treatment is overt. It's treating similarly situated employees differently because of some protected factor covered under Title VII or some other employment protection statute. What defenses do I have if somebody accuses me of disparate treatment discrimination. Well, one defense, maybe the most common one, is called the legitimate non-discriminatory reason defense. We abbreviate that into LDNR. This is a defense to a disparate treatment claim saying that the adverse action was for actually a legitimate reason. It wasn't because I'm discriminating due to their protected class, but I had a legitimate reason for terminating them or demoting them or whatever it is. This can be anything that makes sense as long as it's not related to the prohibited criteria. Examples, very common examples, are things like not showing up to work, showing up late, stealing company property, insubordination, and the other reasons that you can think of for people just getting fired, being on drugs, stuff like that. So if I don't show up to work and I'm a no-call, no-show, they can fire me, okay? Even if I feel like they did it because they don't like me because of my race or because of my gender or whatever, if they have this legitimate non-discriminatory reason, I'm not going to have a very good claim for discrimination later on. Another defense is called the bona fide occupational qualification defense. We abbreviate that into BFOQ. This is a defense that claims that discrimination is permissible if it's legally necessary for an employer's particular business. These are usually only narrowly granted because there's not a whole lot of reasons to have these BFOQs. They're available only for disparate treatment cases involving gender, religion, age, national origin. They are not available for race and color. An example, one of the only examples that I can actually think of, is when you're hiring bathroom attendants, like if you go to a fancier restaurant or nightclub or something like that. When you go into the bathroom, there might be a bathroom attendant there who gives you soap or cologne or whatever, and they help keep the bathroom clean. It's kind of reasonable, even in this day and age, it's kind of reasonable to expect that there will be a male bathroom attendant in the men's bathroom, a female bathroom attendant in the women's bathroom, things like that. So that's kind of understandable. Now, as norms of society change over time, we might see that change, but for now, it seems to be completely fine. So that's disparate treatment. Now we go disparate impact. So this is usually not intentional. You might not even know it's happening, but an employer has some kind of policy that seems neutral on its face. It doesn't seem to be discriminatory at all. But we find out later that it actually does have a disparate impact on some protected group. In other words, we have a policy that we think is reasonable and non-discriminatory, but the effect that it has is that it discriminates against some protected group. So examples might be something like having a height or weight requirement to perform a job. So if I say you have to be over 6 feet tall to perform this job, that's going to have a disparate impact against women, against people from certain people of certain national origins, maybe people of certain races who just statistically aren't that tall. By the way, I'm less than 6 feet tall, so it would discriminate against me too. So I'm not hating here. So this is usually proved in court using a lot of statistics and data gathering in order to show that there's a disparate impact. It's not something that's easily proven, and it's not an easy win. Part of that disparate impact claim is what we call the 4/5 rule, saying there's a disparate impact statistically demonstrated when the selection rate for a protected group is less than 80% of the higher scoring majority group. Now that's an EEOC rule. It's not a hard and fast rule that the courts have to apply. It's more of a guideline provided by the EEOC to help people and help courts understand when there might be a disparate impact claim there, but it is a helpful guideline. Another defense, a defense available to me if somebody is accusing me of disparate impact is the business necessity defense. This is me saying that a policy, maybe it does result in discrimination, but it's necessary and job related. So we might find And this is very common nowadays for employers to run credit checks and criminal histories on people. We might find that running a credit check and running a criminal history, maybe it does discriminate against certain races, people of certain national origins, certain genders, whatever. Maybe it actually does discriminate. It has a disparate impact on them. But regardless, it's necessary because we have to ensure the people that we're hiring aren't felons. They are capable of managing money and aren't more likely to steal from the company and things like that. So if I can justify it using this business necessity defense, that's one way to defend myself against a disparate impact claim. Other defenses available to employment discrimination claims. One, I might be able to just show that the employee's evidence, their entire case, is just simply untrue, in which case that's, relatively easy win if I can do that. It might be that I'm granting wages and promotions and stuff, not on protected characteristics, but on a seniority or a merit system. And as long as I can show that they aren't intended or designed or at least used to discriminate based on a protected class, then I'll probably be okay there. Another defense, and this is something you have to be very, very careful about as employers, because this is something that employers will try to find, is what's called after acquired evidence. And this means that after a discrimination claim, I dig into the case and try to learn as much as I can about it. I might find out something that I didn't previously know about the employee. Namely, they did something wrong that would disqualify them from employment. Maybe I find out they lied on their resume. Maybe I found out that they had been stealing company property. And these actions alone would justify termination. Even if I was discriminating, if I find this after acquired evidence, I could be protected from that employment discrimination claim. Okay, the concept of accommodation. I'm going to add one more in here because one was just added. Let's see here. Updating the content in real time here. Okay, so there are certain things for which an employer will need to try to accommodate an employee. So things that are covered and that I might need to provide an accommodation for are religion under Title VII, disability under the ADA, pregnancy, that's a new one, and the accommodation only applies up to the point where it imposes an undue hardship on the employer. So in the case of religion, somebody comes to me and says, hey, I can't work on Sundays because my religion prohibits me from doing any work. Well, then I need to start looking into this and trying to find out if I can find some way to accommodate that request. Maybe I have other workers who are willing to work on Sunday. Maybe there's a way to just schedule things to where I don't require them to do it. Maybe we can come to some type of compromise where they only work one Sunday a month or whatever accommodation we're working with here. If we can find it and it's reasonable, and if it doesn't impose an undue hardship on the employer, then I have an obligation as the employer to work with the employee. Likewise, the employee has an obligation to notify the employer that they need an accommodation. We'll talk a whole lot more about these accommodations later when we get into these specific topics, but that's at least an intro to the concept of an accommodation. We'll also mention the idea about the exhaustion of administrative remedies if I feel like I've been discriminated against in my workplace. I have an obligation to go through, for a Title VII claim, I have an obligation to go through the EEOC first, before going straight to the courthouse. And that's for a federal claim. A state claim, I might be able to get away from it. It kind of depends on what claim it is, under what law do I think I'm being discriminated against. But if I'm covered by the EEOC, I usually have an obligation to go through the EEOC first so they can investigate and see if they can resolve it first before going straight to court. Okay, what remedies, if I've been discriminated against, or if I'm an employer and I've actually been found liable of discrimination, what kind of remedies are available? Remedies, we're talking about what does the employee get? So back pay would be pay that they should have gotten from the time that the discrimination happened up until now. Front pay is much more rare, but it's the idea that, well, if they had been employed, they would have been earning this amount of money going forward up until they found a new job. So that's possible, but harder. Reinstatement is the idea that they could be given their job back. May or may not be a good idea to go to work in a place where you know they don't like you, but it is possible there. Retroactive seniority, possibly if I'm working under a system that actually acknowledges and rewards seniority. Injunctive relief means that I'm keeping an employer from doing something they were previously doing. Attorney's fees are possible. Compensatory damages is the sort of catch-all term for things like lost wages, future loss, emotional pain, mental anguish. They're compensating me for the injury that I suffered. And we contrast that with punitive damages, or kinds of damages that if a court finds that a company acted willfully or maliciously, fraudulently, then the court could award damages that are designed not to compensate the employee, but to punish the company as a warning to them and other companies not to do that thing. I'm going to briefly mention affirmative action here. We used to have this as an entire chapter, but I really don't think we need an entire chapter for this. There's a whole lot of misunderstanding about the topic of affirmative action. It's not something that most employers and employees really are legally obligated to be worried about, but we'll talk about who might need to be or who just voluntarily does. There's a lot of, like I said, there's a lot of misunderstanding about this. The idea behind affirmative action stems from the tricky history that the United States has with certain races, certain genders, whatever historically disadvantaged groups there might be. The idea is we look at our workforce, compare it to the relevant labor pool. Okay, so what is the composition of my workforce? How many men, women, different national origins, different races? What are the statistics, the statistical breakdowns there? Do I see a large imbalance in my workforce compared to the available labor pool in my area for people who are actually qualified for this job? If I see a large disparity, maybe I should do something about it to try to correct that disparity. It doesn't mean we set quotas. I have to hire 5 new people and they all have to be women, or else I'm going to be in trouble. That would be illegal. But the idea is trying to work toward fixing disparities based on historical disadvantages. There's only really 3 situations in which your company might have an affirmative action plan, a formal affirmative action plan. One is if you're a government contractor who does business with the federal government, then you have to by law. If you're a private company who chooses to voluntarily adopt one, if you're just trying to get ahead of an issue that you spotted and you're saying, we're going to fix this before the government comes in and tries to force it on us, then you might have one or develop one. And then the last one would be a private company who has a demonstrated history of discrimination and has an affirmative action plan forced upon them under a court order. That's really not where you want to find yourself. But it has happened, including to companies in North Carolina. So those 3 situations in which your company might have expressly stated affirmative action plan. Now, a lot of companies are rebranding affirmative action plans, especially the voluntary ones. They're not calling them necessarily, maybe they don't call them affirmative action plans. Maybe they call them diversity, equity, inclusion initiatives to try to include people, to boost the diversity within their workforce, things like that. So we do hear about that quite a lot in this day and age. And over time, that will be rebranded into some other name and then to some other name. So this all evolves over time. Lawful diversity initiatives should be designed to expand opportunity for underrepresented groups without, here's a key stipulation, without also negatively impacting opportunities for those in the majority. So just because I find a racial disparity doesn't mean that I all of a sudden stop hiring white people whatsoever just to boost my diversity. That would be the kind of thing where I'm setting a quota. Again, those quotas are illegal. Reverse discrimination against people of the majority is still illegal. But voluntarily working toward, maybe it could be very simple things like advertising my jobs in places where they hadn't been advertised before, recruiting at schools where I hadn't been recruiting before, where there was more diversity, things like that. So reverse discrimination, don't do that. Setting a quota, don't do that. But having these initiatives to try to include people who have been historically disadvantaged seems to be okay for now. And that's in the workplace. We recently saw a big Supreme Court where they said that affirmative action in college admissions is no longer allowed. That hasn't been applied to the employment environment yet. Or I don't know if it ever will be. I don't know. The historical idea behind affirmative action is that it's this very temporary thing to try to get United States society back to an equal opportunity landscape, and then we no longer need it. And then so, if I'm taking an optimistic view of the future, there's some point at which we don't need any affirmative action or diversity, equity, inclusion initiatives at all. And we can just leave them alone because now America has achieved this utopian equal opportunity society. I don't know if we'll ever actually get there. It's much harder to do than it would sound like. A little bit more here about just some foundational stuff. We're still here in the first couple lessons where we're learning about the legal landscape of the United States, but something, just a little primer on the federal and state court systems. In the federal court system, there are district courts, which are the trial courts, appellate courts, which are the next level up, and then finally the United States Supreme Court, which is the highest law of the land. And if I win or lose at the Supreme Court, then there's really no going beyond that. That decision will more or less be final, at least for the foreseeable future. The state court system is somewhat similar in that there are levels. There's a district court division where I have small claims that are civil claims under $10,000. I have district courts that try like misdemeanors, lower level crimes, and civil claims that are between $10,000 and $25,000. Above that, there's the Superior Court Division, which tries felony crimes, and then civil claims that are above $25,000, as well as appeals from district courts. Then we have the Appellate Division, which is comprised of the Court of Appeals, which is an intermediate appellate court. So if I lost at the district and superior court levels, I could try to appeal to the the Court of Appeals, and they either choose to take my case or not. And then if I still don't win at the Court of Appeals, I can try appealing to the North Carolina Supreme Court, which is the highest court in our state. If I lose there, then I can try to appeal. My last recourse, if I lose at the North Carolina Supreme Court, is to try to appeal to the United States Supreme Court. The odds of getting the United States Supreme Court to hear my case are astronomically low, but it's possible. We mentioned the term stare decisis. We're carrying on legal tradition back from hundreds and even thousands of years ago. Stare decisis is a Latin phrase that just means let the decision stand. The idea, and we've heard a lot about this in the news lately because some important precedents are being overturned. The idea is that when a court decides a certain way on a certain issue, then they follow that precedent that they set and they try to be consistent going forward in the future. That precedent that court sets also applies to other courts in that jurisdiction. So if it's the North Carolina Supreme Court that decides a certain way and sets a precedent, then all the other courts in North Carolina have to decide the same way, all the other state courts in North Carolina. If the United States Supreme Court sets a precedent and they make a decision, then all the other courts in the United States have to follow that same decision. Stare decisis is not an absolute thing. Cases are overturned. It's relatively rare, when cases are overturned or reversed and when stare decisis does not apply. We recently saw it in the case that overturned Roe versus Wade and Casey versus Planned Parenthood, where a long-standing precedent was overturned. So it can happen. It's just relatively rare. The last little bit in this lesson here is just some vocabulary that you might see as you're reading cases. We'll do some case studies in the course. And, legal language is its own language, often referred to as legalese. But understanding the terminology, I think, is pretty important and will make things a lot less confusing when you're trying to read the cases. So most of us are kind of familiar with the idea that a plaintiff is a person who brings a civil action. You're suing somebody else. You're the plaintiff. A defendant is one against whom a case is being brought. An appellant, let's say if we lose at the district court level, whoever wants to appeal would be considered the appellant. That could be the plaintiff or the defendant. Both can appeal. The appellee is the one against whom an appeal is brought. If we go up to like a Supreme Court level, then the person who appeals in that case is called the petitioner, and then the one against whom the case is being brought is known as the respondent. So different names at the different levels. Why is that? I don't know. Legal tradition, again, spanning back hundreds and even thousands of years, and we're kind of stuck with it. And rather than changing all the vocabulary for all of legal history, we just sort of carry those terms forward. A case citation, oftentimes you'll see this where it's like 23 USC, 3rd District, whatever, so-and-so versus so-and-so. That's a case citation that allows you to understand what specific case we're talking about and where I can go to find the full text of that case. If an appellate court agrees, let's say I appeal a case, the appellate court agrees with what the lower court said. They say, well, we affirm the lower court's decision. If they disagree with the lower court's decision, they can reverse that decision, saying they disagree with it. Oftentimes when they reverse or affirm, they'll remand the case back down to the lower court, because the appellate court isn't going to get involved in fact-finding or sentencing, stuff like that. They're just going to say the lower court either did the right thing or they did the wrong thing, and now we're going to give it back to them to finish out the case in its entirety. If an appellate court says that something has been vacated, that means they're rendering this decision by a lower court null and void and not effective anymore. A couple common motions that people will file when a case is brought. One is a motion to dismiss. That means that I, as the defendant, I really don't think that the plaintiff has enough evidence to prove any kind of violation of law. So rather than going through the entire trial process, I'm just going to motion the court to dismiss this case altogether, to save everybody a lot of time and money. It's very common to file a motion to dismiss right away. If that didn't work, I can also file for a summary judgment, meaning that, well, I think based on the documents that the plaintiff has submitted, the court has enough information to make a decision now without having to go through the entire trial process with witnesses and all that stuff. Thinking that there's really no issue here that needs to be decided by the jury. The court can just look at what's been presented and make a decision right away. That can be granted or denied, and can also be appealed, just like the motion to dismiss. Appellate courts can affirm or reverse lower court decisions. Sometimes they'll be remanded back to the lower court with instructions on what to do, saying that, well, we think you decided wrongly about this one key issue, lower court. So now given that, we're giving the case back to you. Given this new information, now go ahead and finish out the trial. For big court cases, there will, especially at the appellate and Supreme Court levels, there will be at least one opinion, like a majority opinion, written by the people, written by the justices who have voted in favor of, whatever, the majority of the court. This is the opinion that's going to matter and the opinion that's going to form law, probably. But other justices who disagree can also file what they call dissenting opinions, saying that, well, the majority opinion thinks this, but we disagree, and here's why. This dissenting opinion doesn't have any legal weight, but it is them expressing their reasoning, why they think the Supreme Court got it wrong or the appellate court got it wrong, and explaining exactly why they think that. Sometimes, I'm going to scroll up here a little bit, sometimes other justices on the court agree with what the final decision is, agree with the majority, but have a different reasoning for why they agree. Well, you decided because of ABC, but I think you're ultimately right, but I think your reasoning's wrong, and I think it's because of, XYZ. That would be called a concurring opinion. A per curiam decision translates into by the court. That's a decision that's rendered collectively and anonymously rather than naming concurring and dissenting opinions. Those tend to be quite brief and can be sometimes frustrating. The last concept I'll introduce to you here is what we call a prima facie case. We'll talk a lot about prima facie cases later when we get into the discrimination chapters, because in order to get a court to take my claim seriously, I'm going to have to bring them enough information that it looks to them at first glance like there has actually been something wrong that happened here. If I have a cause of action when I have the legal right to sue when certain rights have been violated. That's basically my right to bring this lawsuit here. The prima facie case says that the requirements have been met that constitute a party bringing a cause of action. So I have to satisfy some minimum threshold in order to even file this case, or for the court to take it seriously and actually agree to hear this case. It's Latin for at first sight or at first glance, however you want to translate that. But the idea is that, well, it looks like something wrong happened here, but we need to dig deeper, gather as many facts as we can, gather as much evidence as we can to try to get the bottom of this and try to figure out if something wrong has actually happened, if the employer has any liability here, or if the employee was just wrong and there's really no damages to be awarded here. That's enough for now. We threw a lot of vocabulary at you, so you may have to read through these notes a few times just so it all kind of sticks. We'll reinforce all of these concepts later as we move through the course, because we'll be talking about cases. We'll be using some of this vocabulary, so hopefully it'll be reinforced and make a whole lot more sense as we move forward. That's it for now. Always feel comfortable to reach out to me if you have questions or if something doesn't make sense, or if you think I said something that's wrong and you're aware of some new law that I haven't heard about yet. Reach out to me and I'll be happy to update things and correct any errors I might have made. With that, have a great day.